So that means I have to prove jurisdiction, but you got to give me the opportunity. If you don't give me the opportunity, you're violating my rights, Your Honor. Your Honor, for the record, is this matter a criminal matter or a civil matter?
What do you think?
I just want to answer.
You're standing there in handcuffs. You're wearing a jail outfit.
Honor, can you please answer the question for me, please?
That's my answer. I'm answering with a question. What do you think? Lowercase.
I don't know. I don't know, Your Honor. That's why I'm asking.
This is all cap. Is this your handwriting?
What?
That's all caps.
Oh, that's awkward.
This individual just made an appearance in court, and to say it was bizarre would be an understatement. His approach was baffling, to say the least, and the judge didn't hold back when it came time to set the record straight. What followed was a sharp reality check that turned the entire courtroom 10 sand, honestly. You won't believe how far off track things went. The exchange had moments that were almost too unbelievable to be real. Yet every second of it unfolded. Right there in front of the bench. The energy in the room shifted fast, and the judge's response left no room for games or confusion. Let us know in the comments, was this one of the most ridiculous court appearances you've ever seen? Share your take after watching. But for now, let's jump into this chaotic courtroom moment and see how it all plays out. Wait a second, did he just claim the court has to prove it has jurisdiction? That's a legal misunderstanding of epic proportions. It's like walking into a hospital and asking a doctor to first prove that medicine is real before treating you. The authority of the court isn't something up for debates already established under Georgia's Constitution, specifically outlined in Article 6, Section 4. Paragraph 1. What makes this even more puzzling is the fact that he's in custody, physically present in court, and still arguing over the basics of legal procedure.
Okay, let's get on the record, please, Ms. Rivers. This is 24 SC 003257, State versus Ricky Pierce. Mr. Pierce is in court. He was at an earlier proceeding. He and I had a long conversation about self-representation. I've entered an order allowing him to represent himself, or honoring his request to represent himself. Today, we're going to cover three things, Mr. Pierce. One, we need to do your arraignment because we weren't sure if you were going to have a lawyer or be your own representative. I held off on arraignment, so we got to do arraignment. Two, I'm going to, on the record, get you the paper part of your discovery, which you can take with you. And then three, we're going to talk about scheduling so that your case catches up with Mr. Baker's. So let's start with the arraignment.
Before we can get into that, it's a lot of issues that I had that I want to address before we get started with the arraignment. It's a lot of issues, a lot of questions that I have that I need to be answered.
Okay. So why don't you give me an example of one of the questions, and then I'm actually going to decide whether we do arraignment first or your questions first.
Well, the law state that in Hagan versus Levine state that anytime a jurisdiction is challenged, that it must be proven before the case proceeds.
Okay.
And you're trying to proceed with this case without establishing jurisdiction first. That's the law, Your Honor.
Okay. It will work better as you and I are working together on this. If you've got legal concerns, you put them into a motion. So
I have filed a motion already, but Your Honor.
So I'm going to look and see what's in the docket.
It states that a court cannot proceed without establishing jurisdiction first, Your Honor. Okay. This is the law. I'm not saying nothing that's against the laws of Georgia, Your Honor, or the United States.
She can't take down if you talk that fast. She's trying to take down everything you say.
Right. So pause. Just hold on, Mr. Pierce. I'm looking in the docket here, and I'm not seeing that you filed, and it just may not have made it yet, that you filed a motion challenging jurisdiction. But I'm happy to let you know right now, I'm real comfortable with the court's jurisdiction. That doesn't mean I won't.
Your Honor, it states that The proof of jurisdiction beyond a reasonable doubt is asserted. I'm the one asserting jurisdiction here, Your Honor. So that means I have to prove jurisdiction, but you got to give me the opportunity. If you don't give me the opportunity, you're violating my rights, Your Honor.
The courtroom itself is a clear sign that jurisdiction has already been determined. Let's be clear, the state's job is to prove whether a law was broken, not to entertain personal theories about constitutional loopholes. This isn't a movie, and no one here is dodging reality. The legal system doesn't pause for philosophical debates, especially when the evidence and the handcuffs say otherwise. School, is that so? Well, if he's planning to rely on those old constitutional documents as a shield, he might want to settle in it.
I also filed a motion that's right here I have signed by the clerk saying that it's been filed in office. This is the motion right here that I have filed. I have here something, me copies back and everything. And plus, the courts are still trying to proceed with my case when you guys lack subject matter jurisdiction. Plus, it states in Louisville versus Motley, if any tribunal find absent of proof of jurisdiction over a person or subject matter, the case must be dismissed.
Okay, slow down. I'm gonna let you keep reading. Just slow down so Ms. Rivers can get what you're saying.
And also, Your Honor, once jurisdiction is changed, it is to be proven not by the courts, but by the party attempting to assert jurisdiction, which will be me. Your Honor, the burden of proof lies with the assertor.
Going to be a long wait. Those texts have stood strong for over 2 centuries, and not once have they supported the claims often made by self-proclaimed sovereign citizens. Time and again, courts across the country have ruled that these arguments simply don't hold up. Under legal scrutiny, the Constitution of the United States guarantees many rights. But skipping out on traffic laws because of something you read online isn't one of them. No matter how passionately someone interprets it.
Okay, I'm now finding, it just wasn't listed as a motion, but I do see it's in the docket right here, something that you filed. It's entitled
Pro se with a prohibition.
Right, got it. So I've got that. I will rule on that. I'm going to give the state a chance to respond. But you just filed, you filed it a couple weeks ago. And so I'll get input from the state on that. And then I do owe you a ruling on that. That does not prevent us from doing the arraignment.
Yeah, it does, Your Honor, because the law states that anytime a court jurisdiction is challenged, it must be proven before the case can proceed, Your Honor.
Okay.
So I challenged the jurisdiction last month, March the 4th. So that means that you have to set a court date for me to prove that you lack subject matter jurisdiction. That means I have bring my evidence, the state bring their evidence, show jurisdiction, and I'm not a statutory entity, so therefore statutory law don't apply to me, Your Honor.
The law doesn't bend to blog posts, YouTube lectures, or caps-locked manifestos, and Georgia's Constitution. That's not a personalized permission slip to bypass responsibility. When you're already standing in front of a judge mid-proceeding, claiming immunity from basic legal structure isn't a defense, it's a detour from reality. The courtroom doesn't operate on personal beliefs. It runs on established law, and no amount of creative reasoning changes that. School the age-old tactic claiming the law simply doesn't apply to you. It's a bold approach, especially coming from someone with a documented history that includes 10 years behind bars. Clearly, the legal system did apply, and quite decisively at that. It's almost like watching someone declare they're invisible.
Motions.
Okay, let me just take a look here.
I have a lot of questions that I need to be asked.
As long as you read slowly, we'll get through that. Okay, I think I've got your writ of prohibition also. And is that the challenge to jurisdiction?
Is that for fraudulent practices, misrepresentation, and lack of subject matter jurisdiction? Yes.
Okay, I see that. It says for fraud. Yep, they're all there. All right, so you filed them. I'm making a list here of things that I need to work on, and then I'll need to let the state respond. The way it works, if you file a motion, the state gets a chance to respond. Once I have both sides, then I can rule on that. Okay.
I mean, but you're still trying to proceed with the case, Your Honor, when we haven't established, you trying to get me to plead when this case is supposed to be at a standstill when I changed the jurisdiction March the 4th of last month. So that means you have to prove jurisdiction before I even make a plea on this, Your Honor.
I'm fine delaying the arraignment while we work through this. We don't have to do the arraignment today. I can hold on to the discovery and get you that another time. If you would prefer that I let the state respond and then I rule on it, we can handle it that way. Is that what you'd like?
I would like if we can just answer these questions that's had right in front of me today, Your Honor.
So then don't read the motion anymore and tell me what are your
I wasn't
questions.
reading the motion. I was reading what I have wrote down, my issues I have.
Okay, but ask questions instead of telling me about these cases.
Your Honor, I am on, let the record reflect that this is the defendant, this birth certificate, which is the person / persona, which is a legal fiction, also a statutory entity.
And I can't understand.
Okay, I need you to slow down a little bit. So, Ms.
Let the
Rivers.
record reflect, Your Honor, that this birth certificate is the defendant. I'm physically showing the birth certificate, everyone in the courtroom, that this is the defendant and I am the defense.
Okay.
Your Honor, I am only here in this courtroom by special appearance on the threat and duress to administer affairs of the Our Cap Trust, which is this birth certificate.
Okay.
As a sole beneficiary.
You told me you had questions. Tell me.
I'm getting to it. I'm just introducing to the question, Your Honor.
I want you to go straight to the question now.
Your Honor, is this courtroom a court of records?
Decisively at that. It's almost like watching someone declare they're invisible. While standing in the middle of a spotlight, hard to believe, even harder to ignore. The contradiction is hard to miss. Declaring yourself immune to the rules of society while participating in the legal process feels less like a strategy and more like a performance. But in the courtroom, reality always takes center stage, and judges don't tend to entertain fantasy for long. Its consequences, from court costs to sentencing, serve as a reminder that the law doesn't go away just because you say it should, and often. These sovereign citizen arguments come wrapped in big talk about freedom, but let's be honest. The kind of freedom they're usually chasing looks more like a way out of accountability. What they end up finding instead?
Okay, what's your next question?
You can answer it? Is this courtroom a
I
court
want
of
to know what
records?
your questions are.
I'm asking the question, Your Honor, is this courtroom a court of records?
So I thought you were going to share with me what the questions were. I didn't tell you if I was going to answer the questions. You said you had a bunch of questions.
So you're going to have me ask questions that you're not going to answer, Your Honor? That's not fair.
Well, don't ask the questions then. You don't have to ask the questions. You said you wanted to ask your questions, and I'm happy to hear them. If it's appropriate for me to answer them, I will.
So you don't think me asking is this court of records appropriate?
I didn't say it was appropriate or inappropriate. I just needed to know what your questions were. And if they're ones that I should answer right now, like what time is it? I can tell you, 3:51.
Yeah, and I'm asking something very simple, Your Honor. Is this courtroom a court of records?
All right, and what's your next question?
Your Honor, is your courtroom a court of records? I can't get
That
past
seems like
these
the first
questions
question.
need to be answered before, Your Honor. This question need to be answered for me to proceed, Your Honor.
Okay, tell me
I'm
what
trying to get an understanding. If you're not trying to help me get an understanding,
tell me what you mean by a court of records.
is this a court of records? It's simple. It's
I don't know what that means.
Is this courtroom a court of records?
I don't know what court of records means.
Do they record and proceed on everything that's happening in this courtroom? Do they record and document everything that's happening in this courtroom?
I don't know about everything, but as long as as long as you're speaking slowly and clearly, then things are being taken down. What's your next question?
Is this Fulton County courtroom a court of records? The same question you're not answering, Your Honor. You're trying to dodge the question.
No, I'm not. I want to make sure I understand the question.
Is this Fulton County courtroom a court of records?
At times it is.
And are you sure this courtroom is a court of records?
If court of records means we take down what is said in court, then yes, sometimes this is a court of records.
For the record, Your Honor, I go by Ricky DeMond Pierce, all lowercase letters, nothing more, nothing less. Again, I'm here by special appearance on the threat and duress to again administer affairs of the Our Cash Trust as the sole beneficiary and a shareholder of the trust, which again is this birth certificate. Okay, I'm also the executive of this estate, and I'm not the living person, they're not the person or persona, which is a statutory entity. I'm the all caps legal. I'm not the all caps legal official on my corporation. I'm signed by your government agreeing to the same.
So what's your next question?
Your Honor, before we could proceed with this matter, I have a few questions I need for you to answer. First, Your Honor, are you practicing color law behind the bench?
I'm not sure what you mean.
Are you practicing color law behind the bench? Because Title 18, U.S.C. Section 242 clearly states that you are committing a felony if you are doing so. Title 18 states, whoever, under color of any law, statute, ordinance, regulation, or custom willfully subject any person in any state, territory, commonwealth, possession, or district to the deprivation of any rights, privileges, or immunities secured by and protected by the constitutional laws of the United States shall be found under this title or in prison not more than 1 year or both. And if bodily injury results from acts committed in violation of this section, or if such acts include the use, attempted use, or threat of use of a dangerous weapon, explosive, or fire, shall be found under this title or in prison no more than 10 years or both. And if death results from the acts committed in violation of this section, and if such acts include kidnapping, attempted to kill, shall be found under this title or in prison for a term of years or for life or both, or may be sentenced to death. Now my question, let the record reflect that no legal or lawful matter can proceed without jurisdiction, Your Honor. We both know this.
Right. So we're going in circles. We're back.
Let me finish. Your Honor, my question to you is Your Honor, for the record, is this matter a criminal matter or a civil matter?
What do you think?
I just want to answer.
You're standing there in handcuffs. You're wearing a jail outfit.
Honor, can you please answer the question for me, please?
I'm answering with a question. What do you think? Lowercase.
I don't know. I don't know, Your Honor. That's why I'm asking.
There is circulating a guidebook titled How to Ask the Most Unhelpful Questions in Court, because it certainly feels like there's a pattern forming. Here's the deal. The moment a judge says, "We're going on the record," that's not just courtroom formality. It's a signal that every word from that point on matters. It's not the time for theatrics, theory testing, or amateur legal arguments. It's the moment to speak carefully and listen even more closely. Because what you say next could directly impact your freedom. Yes, the court is officially recording the proceeding. Yes, everything said becomes part of the legal record. And now, watching a few online videos doesn't make you qualified to challenge that process. Courtroom procedures exist for a reason. And ignoring them isn't just a waste of time, it can actually hurt your case. At some point, we have to stop treating these questions like harmless confusion and start recognizing them for what they are: distractions that slow the process and show a complete misunderstanding of how courtrooms actually function. You'd think that anyone confident enough to represent themselves in court.
Civil matter, would you be having to use the restroom in front of everyone else?
Oh, no, that's why I'm asking you. I'm coming to you as fast as I know how, Your Honor, and humble as I know how. I don't know. That's why I'm asking the question.
Okay. What's your next question?
Your Honor, for the record, is this matter a criminal matter or a civil matter?
Okay, that would be your next question. That's one you already asked.
Why we can't pass this question, Your Honor, because I lack knowledge to understand what is going on. And I'm telling you this, and it's my authority to let the court know when I don't understand something.
A fair point. I want you to let me know when you don't understand. We already covered that when we had our Feretta hearing. We talked about what kind of case it is and the penalties you face.
I said, is this a criminal matter or a civil matter?
How much more time do you need? Because you got about 3 minutes before I'm going to bring someone out here that we can move the case along.
Your Honor, I just want you to answer my questions because I lack knowledge to understand what's going on. I'm just trying to keep caught up to date to understand what is going on.
Okay.
There's no harm in that, Your Honor.
What's your next question?
It's the same question. Before I can get to the next question, I have to answer this question.
Go to the next question. You just said you're not going to answer.
Your Honor, for the record, is this matter a criminal matter or a civil matter, Your Honor?
All right, we're done. I will bring you back once the state has responded to your motions, and I will likely be entering an order that lets you know my thoughts about jurisdiction. Once I've done that, you can choose to participate in an arraignment, but you do need to understand that in a criminal case, that's a clue.
So this is all criminal matter. Why you couldn't answer the first time, Your Honor?
Why are you asking in the first
Because
time?
I'm trying to get, I just told you I'm trying to get an understanding.
So let me finish. So you understand that in a criminal
So
case,
this is a criminal matter, for the record.
such as yours, if you choose not to
Objection,
participate,
Your Honor.
if you choose not to
Is this a
participate,
criminal matter or a civil matter, Your
you
Honor?
need to stop interrupting, okay?
I'm trying to understand something. It's my right to, if I don't understand something, to bring it to your attention, Your Honor.
Court would take the time to understand the basics, like whether they're involved in a criminal or civil case, or whether the judge has proper jurisdiction. That's foundational knowledge, not advanced strategy. But in this case, that level of preparation never even made it to the starting line. Instead, what we see is someone more focused on repeating lines from internet videos and presenting unofficial documents than learning the actual rules of the courtroom. It's less about legal defense and more about performance, one that ignores the reality of how courts functioned. Imagine showing up to a football game holding a tennis racket completely, convinced you're ready to play, and then arguing with the referees about how touchdowns should be scored. That's what it feels like when someone stands before a judge and tries to rewrite the process based on flou. The courtroom isn't a place for improvisation. It demands structure, understanding, and respect for procedure, none of you, which can be substituted by internet theories or self-styled logic. That's just not how the Constitution operates. The court is required to clearly inform you of the charges brought against you. That's a fundamental right. But it's not the court's job to walk you through every detail.
We'll bring you back for an arraignment. You can participate or not, but we'll have cleared that hurdle that you.
If you haven't, I'm not going to participate. If you can't establish jurisdiction over my case first, why would I participate?
You don't need to participate. I'll bring you out. You can say no, thank you. We take you back there. We bring the jury in.
I mean, Your Honor, I have issues, and it's
You do.
yeah,
You do.
yeah, and we both do, Your Honor.
And my responses, do I address them to, as Mr. Pierce has recognized to start the day as lowercase r, P, the rest of his name, because he signs all of his motions with uppercase R, uppercase P, uppercase.
No, I don't. I do uppercase or lowercase everything else. Dash. I don't have an sentence. I have an autograph.
It's just different. Out of respect, I just was curious, since it's different than what he.
Let me show you.
I got it right here.
Right. No, I'm looking at it. It's capital R, capital
Lowercase.
P.
No.
Oh, yes. But that's all right.
Is that all caps?
No, it's not all caps, but you capitalize each
Yeah,
word.
This is all cap. Is this your handwriting?
Well.
That's all caps.
And respect for procedure, none of you, which can be substituted by internet theories or self-styled logic. That's just not how the Constitution operates. The court is required to clearly inform you of the charges brought against you. That's a fundamental right. But it's not the court's job to walk you through every detail, like it's a school lesson or to explain the law in cartoon level. Simplicity. That's exactly why legal counsel exists, to help navigate complex legal procedures and ensure your defense is properly handled. Trying to turn the courtroom into a personal classroom where the judge plays teacher isn't going to earn you any extra time or sympathy. These proceedings follow strict protocols, and asking the court to break them down in elementary terms only signals that you're not prepared, or perhaps not willing to engage with the process seriously. At this point, the charges have been stated multiple times, and continuing to act confused won't change their severity. Repeating phrases like, "I don't consent," over and over doesn't make them. Legally binding it just delays the inevitable. And let's not lose sight of the stakes here. When you're facing the possibility of a mandatory life sentence, every minute spent avoiding the facts is a minute lost in mounting a real defense. It's time to step out of online fantasy and into courtroom reality. This judge was clearly made for moments like this. You can see it in his calm, almost amused expression. He's completely
Stop by y'all government saying I'm not the all caps.
I will not
I'm
use
not
all
the
caps.
corporation.
I will not use all
Signed by
caps.
you guys government.
You guys, okay.
Because I'm a national, not a citizen. Y'all are citizens. I'm not.
I remember you establishing that before. We don't need to cover that again.
It was
Anything else?
very much that I present it at every court because it's for the record. Now it's my job to put it on the record, Your Honor.
Okay, it's back on the record. We're incorporating in this hearing what you put on the record at the last hearing, and we'll do that every time. Anything else you want to cover? Because I'm happy to give you this discovery, but you can't have it.
I don't want to
until we do
proceed
arraignment.
until I get my question answered, Your Honor.
All right, why don't you do this? If you want to put them in writing, you could file them and I can get you those answers. But we're wasting not your time or mine, an important conversation, but there are a lot of other people here who are stuck while you ask questions like, is this a criminal matter or a civil matter? So.
Right, because I don't understand.
Okay.
And I just want to ask you where is the problem just answering the question, Your Honor? Because I let the knowledge to know.
Okay. I feel your lack of knowledge, and I'll bring you back after I've responded to the motions you filed. That's the way we're going to interact here. If there's something you want an answer for or ruling on, you need to file it. And you know how to do it. You did it well. Okay? I'll keep your discovery warm and dry in my office.
So would you just continue this court date or something?
Yeah, we can't do the arraignment today. You've helped me understand why. You want me to
Because
establish.
you can't proceed with my case until you establish jurisdiction over my case, Your Honor.
That's right.
That's the law.
It is the law.
So what's the problem with me asking the question to better understand what's going on?
Because, I don't even have jurisdiction yet. Let me establish that, then I'll be in a position to have a conversation with you.
And we're not talking about statutory jurisdiction. We're talking about the Constitution jurisdiction.
We're talking about whatever jurisdiction I find. Okay? I'll see you soon.
Bye, Judge.
That went differently than I expected. Really? I thought just by letting him vent that first time, he's sort of like he purged himself. Clearly not.
There's a strange kind of fascination in watching someone double down on a flawed strategy while the judge remains cool, collected, and quietly in control. And that's what makes it so compelling. The judge isn't angry or confrontational. He's just letting the proceedings unfold. Giving this person all the row what we just witnessed was nothing short of astonishing. This individual genuinely walked into court thinking he could outmaneuver the legal system using recycled internet theories and little to no understanding of how the law actually works. It was as if he skimmed a forum on how to avoid jail in 5 easy steps and treated it like gospel, no research. No legal grounding, just bold confidence and a shaky plan. But major credit goes to the judge in this situation. His approach was a masterclass in courtroom control, sharp, composed, and completely unfazed by the confusion unfolding in front of him. Not once did he allow emotion to override reason. Instead, he calmly addressed each misguided claim with actual legal precedent and crystal clear facts. Watching him dismantle one flawed argument after another without ever raising his voice was something to admire. In a courtroom filled with noise, he brought focus, authority, and balance. That kind of patience and professionalism deserves real recognition. So, what do you think? Did the judge handle it the right way? Drop your thoughts in the comments. I'm curious how you'd rate his response. And if you're into these wild courtroom showdowns as much as I am, don't forget to hit that subscribe button for more breakdowns like this.